Good day, ladies and gentlemen, and welcome to the Employee Benefits broadcast. At this time, all participants are in a listen-only mode. Should anyone require technical assistance during today's conference, please press star then 0 on your touch-tone telephone. I'd now like to turn the conference over to your host, Mr. Isaac Morris. Please go ahead.
Thank you. Well, welcome everyone to our third and next to last benefits broadcast this year. As stated before, my name is Isaac Morris, and I'll be moderating the discussion today. And we're going to start out by reviewing a few housekeeping items and taking care of a few other bits and pieces. So these are the standard housekeeping items that we usually cover. Hopefully you don't need any tech assistance during the presentation, but if you do, please go ahead and call 866-493-2825, and someone will assist you. Again, that number is 866-493-2825. Likewise, if you have any audio assistance that you need, go ahead and dial star 0, and someone will assist you with that. If you want to ask a question, and we hope that you do, use the pull-down Q&A menu to do that. And then if we have time at the end of the broadcast, we'll try to answer your question then. If we run out of time, we'll follow up with you later by an email after the broadcast ends. Just a few more items here. You do have the ability to maximize the PowerPoint presentation by hitting F5 on your keyboard. You also have the ability to print the presentation by clicking the printer icon in the lower right-hand corner, converting the presentation to a PDF, and then printing as usual. As noted on this last bullet point, we'll be applying for HRCI and CLE credit after the web conference. To qualify, you want to make sure that you log into both the audio and web portions of the program. And for those of you who are seeking New York CLE credit, hopefully you know that you're required to complete a new CLE form. And as part of that form, you need to enter a 5-digit code that we'll be providing later on during the presentation. And then go ahead and send that form back to us here. And then finally, we hope that you'll take time to complete the quick survey that will be provided at the end of the broadcast. We do value your feedback and try to base new presentations off what we hear from you. So we have another good discussion planned for today. We'll start off by hearing from Greg Douche, who's going to be talking about some recent litigation involving the new fee disclosure rules and, unfortunately, the possibility of more litigation that could happen as a result of those rules. But at the same time, Greg is also going to provide some advice on how to reduce the possibility of such litigation happening to you. After that, Casey Fleming is going to discuss a number of important items involving disclosures. And as anyone who's worked with welfare or retirement plans knows, there are at least a handful, if not a few dozen, disclosure rules that need to be followed. And Casey's going to go through a number of items that you should be aware about. And then finally, Lee Riley is going to talk about one of the more recent disclosure requirements, the summary of benefits and coverage, or what's sometimes referred to as the SBC. And in particular, she'll discuss some of the detailed requirements that go along with that new disclosure. And with that, I'm going to turn things over to Greg.
Thank you, Isaac. I would imagine that many, if not most of our audience today has heard repeatedly about the new Section 408B2 fee disclosure rules. These are the rules that require service providers to report direct and indirect compensation to the plan, and that require the plan, in turn, to provide additional fee disclosures to plan participants. The result of the new rules is that between the information that's reported on the Form 5500 annual return and the information that will now be provided in the new fee disclosures, there will be considerable transparency regarding fees. In today's discussion, we will not go any further into the nuts and bolts of the new fee disclosure rules, perhaps thankfully, as I'm sure that most of you have already heard enough presentations about the detailed requirements of the new 408B2 fee disclosure regulations. However, what we want to do today is to use the new fee disclosure rules as a backdrop for asking a larger question. That is, if extensive fee information is or will be readily available, including to plan participants and others who may have an interest in fostering fee litigation, does that suggest that we might see more litigation over 401k and other plan fees in coming years? And if the answer is that more fee litigation is likely, what should a plan fiduciary do? In my opinion, the answer to the first question is that we are likely to see more fee litigation. Over the past few years, there have been a number of lawsuits brought alleging excessive fees, and the plaintiffs, that is, the folks bringing the lawsuit, haven't always fared well. For example, there was a case arising out of the Western District of Wisconsin involving John Deere Corporation, in which the court had no difficulty rejecting the challenge and finding in favor of the plan fiduciaries. However, if you are listening to this from the plan sponsor's perspective, don't get too comfortable. In April of this year, there was a case involving ABB Incorporated that challenged 401k fees. And of course, what literally jumps out is that ABB was found liable for $35.2 million. That's right, $35.2 million. Obviously, a number of that magnitude grabs one's attention, and more importantly, it brings into focus the importance of plan fees and how plan fiduciaries evaluate the fees that are being paid. While I believe that there will be an uptick in 401k fee lawsuits, the question of whether those lawsuits will be successful depends upon how plan fiduciaries respond to the new environment. This is where the ABB case might be helpful. Beyond the $35.2 million headline, what did the court find so troubling? In the case, ABB was determined to be liable because, according to the court, it failed to monitor the fees, including revenue sharing payments, made to the plan trustee, and it failed to negotiate rebates to capture some of those revenue sharing payments for the benefit of plan participants. In this connection, certain administrative costs were paid by the plan and thus charged against participant accounts, and in the court's opinion, a portion of the revenue sharing dollars could have and should have been used not for the trustee's compensation, but to reduce these other plan administrative costs. When the court said that ABB failed to monitor the fees, the court was particularly bothered by ABB's lack of a process for reviewing the total fees or compensation received by the trustee and comparing the total fees and compensation to market levels of compensation for similar services. We will return in a few minutes to the concept of process because the court comes back to it time and time again. Let's take a quick step back to talk about terminology. In this case, in addition to whatever direct compensation it received, the trustee received revenue sharing payments. Revenue sharing simply refers to amounts received by the trustee from third parties in connection with the plan or plan investments. For example, when plan assets are invested in a particular mutual fund, the trustee might receive a payment from the mutual fund that is in addition to the compensation that the trustee receives directly from the plan or from the plan sponsor. This type of indirect payment, called revenue sharing in the case, is extremely common in the financial services industry. So we can't dismiss the ABB case as involving a type of payment or compensation that was unique to ABB or that doesn't typically occur. Rather, I would hazard a guess that all or nearly all of your 401k plans involve revenue sharing payments. The question is who keeps them. In the ABB case, the trustee got to keep them. The trustee's total compensation was the sum of the direct compensation received from the plan or plan sponsor and these revenue sharing or indirect payments. That is the crux of the ABB case. Under the terms of ABB's agreement with the trustee the trustee got to keep the revenue sharing payments as part of its compensation. The question being raised is whether the trustee's total compensation package, including the revenue sharing payments, was reasonable. If the total compensation package is not reasonable, the plan fiduciaries who approved the contract have breached their fiduciary duty and may have entered into a prohibited transaction. In the ABB case, one of the factors that bothered the court was that the plan fiduciaries did not even know how much the trustee was receiving in the form of revenue sharing payments. Thus, the plan fiduciaries didn't know how much the trustee was making from the relationship. And how could the fiduciaries judge the reasonableness of the total compensation package of the trustee if they didn't even know how much the trustee was being paid? Just to be clear, the court didn't say that it was illegal to permit the trustee to keep some or all of the revenue sharing dollars. That's not the lesson of the ABB case. But what bothered the court was that ABB, in the court's opinion, did not have in place a process, there's that word again, to review and monitor the trustee's total compensation package and to compare it to market rates of compensation for the services being purchased by the plan. According to the court, there was no evidence of a market review of what the trustee was being paid compared to what a reasonable provider would expect to earn for the services provided. Of course, the ABB plan fiduciaries might have been at a disadvantage in that for the years in question, information about the amounts of revenue sharing payments might not have been easily available. This is one thing that the Form 5500 rules and the new 408B2 fee disclosure rules are intended to change, to make certain that plan fiduciaries have this fee information. So it undoubtedly is a fair statement to say that, as a result of the Form 5500 disclosures and the new fee disclosure rules, that plan fiduciaries today will have more readily available information about a service provider's total fee package, both the direct fees and the indirect fees such as revenue sharing, than was previously the case. But the court's opinion, fairly read, focuses not on the availability of the information, but rather on what plan fiduciaries do with the information. As plan fiduciaries, you will now have fee information. The question that the ABB court was asking, and the question that future courts may be asking, is what did the plan fiduciaries do with that information? Did they evaluate the reasonableness of the service provider's compensation package? Did they attempt to compare it to market? That is the real lesson of the ABB opinion. This is what the court means when it refers to the lack of a deliberative process, a meaningful review of the reasonableness of the contract, and that's what the court found lacking in ABB, and that's what the court found to be so important as to what should be there. One last point about the ABB decision. The court also focused on the investment policy statement, which the court described as an important component of the documents that govern the operation of the plan. The court further noted that the ABB investment policy statement required that rebates be used to reduce administrative costs. One might discuss whether or not the court was correct in its conclusion, but the court viewed the revenue sharing payments as rebates. Thus, the court said, allowing the trustee to retain the revenue sharing payments as increased compensation was inconsistent with the investment policy statement, which contemplated that these rebates would be used to reduce plan costs. So the result in ABB was a $35.2 million judgment. If we take a step back, let's ask ourselves, what does all this mean in terms of practical takeaways for us? First, for any plan that allows the service provider to retain the revenue sharing payments, consider negotiating a flat service fee to which the vendor is entitled. Then, the revenue sharing fees that the vendor retains are credited against the flat fee. If the revenue sharing fees are insufficient to cover the entire flat fee, the plan owes the provider a differential payment. If the revenue sharing fees exceed the negotiated flat fee, the excess is returned to the plan. Many plans have already switched to this type of structure. If your plan has not, it is something to consider. Second, even if your plan is structured to permit the vendor to retain the revenue sharing payments, the plan fiduciaries must periodically review the arrangement to make certain that it continues to be reasonable. That is, even if the arrangement was reasonable at the time the contract was entered into, taking into account the level of revenue sharing payments expected, things change over time. Of particular importance here is that some of these fees are expressed as a percentage of plan assets. For example, 25 basis points or 0.25% of the assets that are invested in a particular investment option. So, as additional contributions are added to the plan, the service provider gets an automatic increase in compensation. In good market conditions, as the value of plan assets increase, the service provider's compensation also increases. Over a period of years, the amount of revenue sharing payments might be vastly different than the amount that was contemplated when the arrangement was being entered into. Again, there is nothing inherently wrong with revenue sharing dollars or in paying a service provider in the form of revenue sharing dollars. But the point is that there needs to be a periodic review and evaluation process. Third, and related to our second point regarding the evaluation of revenue sharing payments, every plan should have in place a process for reviewing and evaluating total fees. The emphasis here is on total fees. So this does not just mean an evaluation of the direct fee paid by the plan or the plan sponsor to the service provider. This does not just mean an analysis of the published mutual fund expense ratio. What needs to be reviewed is the total fee package, including money, if any, that the service provider receives in the form of revenue sharing payments. And once there is an understanding of total fees, which should be easier now with the fee disclosure rules, that total fee likely should be evaluated against the market rate of compensation for the trustee or record keeping or whatever services are being purchased. This is the process that the ABB court and likely future courts were and will be looking for. Finally, the ABB case brings us a reminder about the importance of documents, of the importance of making certain that documents are consistent, and the importance of making certain that the documents, including the investment policy statement, accurately reflect how the plan is being administered. In our experience, the investment policy statement often is put forward with little thought. A one-size, off-the-shelf document in which someone wants to insert the plan and plan sponsor name, but not otherwise worry about the substance of the statement and to not worry about whether the investment policy statement accurately describes what is really happening. The ABB decision indicates how dangerous this might be by focusing on, at least what to the court seemed to be an inconsistency between the policy statement and the manner in which the trustee was compensated. What this points out is that a poorly worded investment policy statement or a statement that is not followed in practice might be worse than not having an investment policy statement at all. So the new fee disclosure rules, in conjunction with the prior Form 5500 requirements, will provide a lot of information, including to people who might be inclined to challenge or to encourage plan participants to challenge the 401k fees. What plan fiduciaries need to do is to engage in and document a systematic process for reviewing and evaluating the reasonableness of their benefit service contracts. Although the $35.2 million verdict in ABB grabs the headlines, the importance of the case is that a documented review and evaluation process is the real lesson. And with that, I'll turn the program over to Casey Fleming, who will review more troubling developments in the participant disclosure context. Casey?
Thank you, Greg. As you may have guessed from the title and Greg's introduction, I will be going into some additional detail about the risky business of participant disclosure requirements. I think that being aware of the disclosure rules and of the potential risks associated with them may be more important now than ever, considering the growing number of participant disclosures. To highlight this point, I will be discussing some of those participant disclosure requirements and a few recent cases which highlight the importance of accurate and clear participant disclosures, and then finally outline a few best practices for plan administrators and their legal counsel. As many of you know, ERISA and the Code have extensive participant disclosure requirements. In addition to the fee disclosure rules that Greg just discussed, you have your SPDs and SMMs, COBRA notices, the annual notices such as the Women's Cancer Notice and the CHIPRA Notice, claim and appeal denial communications. So this would include EOBs as well as any letters that are written when a participant, when a participant's appeal is denied, the account and pension benefit statements, and then the new SBC requirements that Lee will be talking about later. One of the reasons the participant disclosure rules are so important is because the disclosures required by ERISA or relating to an ERISA plan are typically treated as a fiduciary act. In order to satisfy the ERISA requirements and meet the fiduciary duty, plan administrators must ensure that disclosures are, 1, written in a manner calculated to be understood by a plan participant, and 2, sufficiently accurate and comprehensive to reasonably apprise participants and beneficiaries of their rights and obligations. As many of you are aware, there are a number of penalties for failing to make disclosures in line with the rules. The first is just a breach of fiduciary duty action that could be brought by a plan participant or beneficiary. There are the monetary penalties under ERISA. An example of the monetary penalties is the 100-day penalty for failure to timely deliver an SPD following a participant request. And then in addition, there are also excise taxes under the Internal Revenue Code. In addition to the traditional penalties that I just listed, plan sponsors must also be aware of certain equitable remedies. Although I'm not going to go into a ton of detail about Cigna versus Amara, the most recent and frequently discussed Supreme Court case that highlighted the possibility of equitable remedies in this context, I did want to remind you that Cigna addressed certain misleading disclosures that were made to participants following Cigna's conversion from a traditional defined benefit pension plan to a cash balance plan. As a reminder, some of these disclosures included an SPD disclosure which told participants that their benefit would be enhanced as a result of the conversion to a cash balance plan, when in fact many employees were actually worse off than if the old design had remained in place. As a result of these disclosure errors, certain participants made a claim for benefits under the term of the plan under ERISA 502A1, and it is very important to remember that in this case the participants did not make a claim for equitable relief, just a claim for benefits under the plan. Once the case reached the Supreme Court, the court found that there was no contractual remedy under ERISA 502A1, which is what the participants were requesting, because when the participants make a claim for benefits, the court is required to look at the terms of the plan, and the court held that the SPD was not considered the terms of the plan. So that was good news for plan sponsors and plan administrators, that the SPD was not considered the terms of the plan. However, the Supreme Court then went on to say that even though there was no contractual remedy, all sorts of equitable remedies could be available. The 3 equitable remedies outlined by the Supreme Court were reformation of contract, and this would be when the court actually requires the plan sponsor to change the terms of a plan and then enforces those revised terms If you recall, and I didn't discuss this in this presentation because it would take too long to go into this entire case, but this is similar to what the lower court wanted to do in Cigna. The second was estoppel, and for an estoppel remedy, the court would hold plan sponsors to a promise which was made to certain participants in a disclosure. For example, if the disclosure had promised additional benefits that were not, in fact, in the plan document. And third, surcharge, which is a monetary penalty that can be imposed for a loss resulting from a breach of fiduciary duty or to prevent a fiduciary's unjust enrichment. Just to highlight, equitable remedies are a very big deal, and I'll be going into this in some more detail later, because they make participant disclosures even more risky. They're essentially available even if the plan is operating 100% consistently with its terms, but because of a participant disclosure error, the terms were not actually communicated to the participants. The next case tells a cautionary tale about including a provision in the SPD. In this case, it was the claims and appeals deadlines, but not in the plan document. So this is essentially the opposite of the facts in Amara, which included something in the SPD that was not in the included something in the plan that was not in the SPD. In Kaufman versus Prudential, a participant was entitled to and started to receive long-term disability benefits, but 7 months into receiving these benefits, Prudential, her employer, terminated them because they concluded she was no longer disabled. The claim denial letter that was issued to the participant on February 23, 2006, stated that she had 180 days to appeal the denial of long-term disability benefits, and that is, the typical and required time period. But instead of filing an appeal within that 180-day time period, the participant filed an appeal on February 17, 2009, which was just shy of 3 years after the claim denial was issued. In addition to filing that appeal, the participant also filed a suit in court the following day. On February 26, 2009, Prudential timely informed the participant that they would not consider the appeal because it was untimely under the 180-day period. So just so we can review the documents that were issued in this case, the participant disclosure documents, the SPD, like the claim letter, stated that the participant had 180 days to file an appeal, but the plan document was silent on this point. It only stated that a lawsuit could be initiated within 3 years from the date proof of loss is required. And I think that this is probably a pretty common provision in many fully insured plan documents, so it's certainly something to be aware of. And then also, and this is very important, that the SPD explicitly stated that it does not constitute part of the plan. So the district court level, the participant alleged that the 180-day appeal period was unenforceable because it was not in the plan document, even though it was in the SPD and the claim denial letter. And the court agreed with the participant and cited to a DOL regulation that requires every plan to establish and maintain reasonable procedures governing the appeal of adverse benefit determinations. The court also rejected Prudential's argument that the SPD was in fact a part of the plan for 2 reasons. First, the SPD actually said it was not part of the plan. And second, as we discussed earlier, the Supreme Court in Amara said the SPD is not the terms of the plan. So a few takeaways from Kaufman. If SPD provisions are part of the plan document, be sure to clearly say so. This often comes up when employers use umbrella, or some people refer to them as wrap welfare documents, which do not contain all the terms and conditions, but then cross-reference the SPD. And then alternatively, for plan sponsors that do not have an umbrella or wrap document, just to make sure that you have more full-blown plan documents and ensure that all the important SPD provisions, including claims and appeals timelines, are also in the plan document. connection with Kaufman, I also wanted to point out that although the holding is that a provision in the SPD is not enforceable because it was not in the plan, don't expect that same result if the SPD had promised more benefits than the plan document intended. This is pretty much just a general reminder of the AMARA Equitable Remedies, that being that, if a participant is promised something better in a participant disclosure, there is a pretty strong possibility that, they could file and possibly be successful in a suit based on the equitable remedies we discussed earlier. The next case is going to expand on the importance of cross-references in participant disclosures. I will say this is one of my favorites. It's a real gem. So in Kitterman versus Coventry Healthcare of Iowa, the plan participant had read the first 2 pages of a 3-page summary of health plan benefits. And in those first 2 pages, the summary explained that the out-of-pocket maximum for a non-participating provider was $8,000. But then the 3rd page went on to clarify that any amounts in excess of the out-of-network rate do not count towards that $8,000 maximum. So in other words, the $8,000 maximum was only based on amounts that fell within the out-of-network rate. So the participant had gone to the Mayo Clinic, which under the terms of the plan was a non-participating provider, on the assumption that the maximum exposure to her was $8,000. But because of that rule that we just discussed, she was told that she was actually responsible for $23,000 of unpaid benefits because that amount was in excess of the out-of-network rate established by the plan. So as a result of this extra money she had to pay, the participant decided that she'd sue because the 2nd page did not invite the reader to turn the page or otherwise indicate that the phrase out-of-pocket maximum meant something other than plain interpretation. So again, the participant sued because she thought she was not invited to read the 3rd page of a 3-page summary. And somewhat unbelievably, the lower court agreed with her, and the plan sponsor appealed that decision to the 8th Circuit Court of Appeals. Thankfully, the 8th Circuit Court disagreed and held that the participant must review the document as a whole. And I want to note here that we should all be aware and keep in mind that this holding possibly could have been different if the document issue had been, 100 or 150-page SPD instead of just a 3-page summary. It begs the question as to whether or not a participant is actually required to review a document that's that long and as a whole. And so when the 8th Circuit disagreed with the district court, they remanded it back to the lower court for the decision as to whether there was a conflict between the summary and the plan document, similar to the other case we just discussed. And the court reviewed that and held that there was no conflict, that the participant was in fact liable for the excess charges. So even though the court made the right decision here, we have to ask the question, at what cost did that decision come to the plan sponsor? And this reminds us of an old adage, for want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of a horse, the rider was lost. For want of a rider, the message was lost. For want of a message, the battle was lost. For want of the battle, the kingdom was lost. And all for the want of a horseshoe nail. So, in our context, for want of a cross-reference or indication to read on, a plan sponsor was involved in a lot of litigation and probably had to spend a lot of money. The next case will discuss the importance of clarity and significance in participant disclosures. Townsend versus SC Johnson related to the circumstances in which SC Johnson had implemented a cash balance plan. And under the terms of the plan, participants would receive annual interest credits, which were equal to the greater of 4% or 75% of the return on the plan investments. However, when someone left the plan before reaching their normal retirement age, the plan sponsor had not been giving them additional interest credits, and instead they were just calculating the lump sum by projecting the account balance forward using the 30-year Treasury rate and then discounting it back using that same rate, which, it had the effect of essentially just paying out the lump sum that was exactly equal to the distribution or to the account balance the participants saw. And so again, instead of projecting out the balance using the interest crediting rate, like they should have under the law at that time, and then using the IRS rate to present value it back, they were just using the same rate to go out and then back again. And although their method of calculating this was improper during the time of question, I just wanted to point out that it is an acceptable plan design now. So because they were calculating the benefit that way, and so that the amount of the lump sum was the same as the account balance, the SPD clearly described for participants that the entire value of your account is paid in one payment. And then there were some additional newsletters that stated that the lump sum distribution would be the amount in the cash balance account. So if you terminated, the amount you would get prior to age 65 is the amount that was in your account. So the class action was filed for claims for bigger lump sums because of the error that was happening in calculating the lump sums. And SC Johnson's defense to that claim was that they were time barred. So under the facts and in the jurisdiction that they were in, a case of this sort had to be brought 6 years from when a participant knew or should have known of the conduct giving rise to the claim. And SC Johnson said that participants were clearly on notice about how the lump sums were calculated because the materials provided and that we just discussed were given to participants more than 6 years prior to the claim filing date. And as a result, the statute of limitations had run and the action was time barred. The court found that those particular disclosures were not good enough to start the running of statute of limitations. Specifically, the statement that the entire value of your account will be paid in one payment. I'm sorry, I think I'm having a problem with my slides. I'm sorry, excuse me for just 1 second. There we go. Specifically, the statement that the entire value of your account will be paid in one payment did not explain how that value is decided, and that the SPD statements did not describe that early lump sum distributions would not be increased to reflect that interest credit that we talked about earlier. There we go. The court went on to explain that a person who is familiar with future interest credits might still assume that those future credits were somehow incorporated into the account balance, even though it was very clear that the participants were receiving the amount that was in their account balances. And also that newsletters did not carry the weight of an SPD because they were not likely to alert a participant that he was being deprived of a right. So takeaways from SC Johnson. Carefully consider disclosures about potentially controversial or unclear issues. This is sort of a joke, but not entirely. Consider very detailed explanations, such as your lump sum payment will be equal to your account balance. Your account balance is your annual allocations plus the interest credits made to date. Nothing more, no adjustments. Really, we mean it. It's the same as what you think of as a 401k balance. Whatever is in the account, that's all you get. Also, carefully consider the use of newsletters versus formal summaries of material modifications, and make sure that all communications, whether they are formal SMMs or newsletters, indicate that it will be discussing important rights and that it's treated as a supplement to the SPD. So just moving on, some best practices for plan administrators and legal counsel. Check each provision of an SPD against the plan document, and then check whether each provision of the plan document is summarized in the SPD. We really think this is the only way to confirm that both documents are coordinated and all of the important rules in the SPD are also included in the plan document and vice versa. Read all of your disclosures for legal rules. Is the statement legally correct? Are all of the SPD requirements included? and then reread to make sure that the disclosures are clear and understandable, internally consistent, not redundant, and that they include appropriate cross-references. Rethink typical disclaimers, such as the plan controls if inconsistent with the SPD, or this is only a summary of a legal plan document. Rather, consider whether it should say something like, the eligibility, enrollment, and benefit provisions of this SPD are part of the plan. Other provisions in the SPD summarize detailed provisions contained in a separate plan document. If you'd like a copy of the separate plan document, contact X. Non-SPD disclosures should clearly state their importance, including if they are intended to, in fact, be an SMM. And don't try to hide bad news, and be sure to explain the consequences. For example, if you don't enroll in COBRA by the 60-day deadline, you will permanently forfeit your right to elect COBRA continuation coverage. Finally, audit participant communications and disclosures being provided by your vendors. This includes EOBs and appeal denials. And ensure that your contract requires vendors' legal compliance and provides for adequate indemnity for the plan sponsor. The last slide is just the case sites in case anyone is interested. So at this time, I will turn it over to Lee.
Thank you, Casey. I'm going to talk about the new summary of benefits and coverage and something called a uniform glossary at the very end. This is another wonderful new disclosure brought to us by Patient Protection and Affordable Care Act, and it deals with health plans only. The purpose of these new SBCs is to basically help employers and employees to better understand their health care coverage so that they can go out and basically comparison shop. This will be especially important starting in 2014 when the new state healthcare exchanges go online, and presumably employees then can really have choices between their employer coverage or buying insurance on the exchange. So let's talk about, let's talk about which plans have to provide an SBC. So it's all group health plans with certain exceptions. And in a group health plan, it doesn't matter whether your plan is self-insured or fully insured, you need to provide an SBC. And as a reminder, there are certain types of plans that you might not always say, oh, that's a group health plan, such as a health reimbursement accounts. Those are considered self-insured health plans, and they would have to provide an SBC, although we'll talk a little bit later about maybe how you can talk about your HRAs in connection with the general medical plan. However, there's a long list of accepted benefits. If you've gone to any presentations about the Affordable Care Act, this is the typical list you always hear about as being exempted from a lot of these new requirements, such as standalone dental or vision plans, and those are plans that aren't integrated with medical. You can, separately elect dental, and there's a separate premium and separate enrollment. Health savings accounts are exempt. Most medical flexible spending accounts, the only time a medical flexible spending account wouldn't be exempt is if there were employer contributions going into that account in addition to employee contributions, and if basically the medical flexible spending account was the only health care plan you're providing to your employees. But the typical run-of-the-mill, employees contribute to a flex account, those are going to be exempt. Retiree-only plans are exempt. And the last one is not a typical exemption from healthcare reform, but we got a little reprieve of 1 year from providing SBCs, and that's expatriate coverage. Because employers have been complaining to the government that, look, our expatriate coverage really varies from location to location. It's going to be difficult to provide an SBC, and so the government at least gave us a 1 year exemption from having to do an SBC. Okay, so who provides the SBCs and who is supposed to receive them? Well, if you have a self-insured plan, it's the plan administrator's obligation to provide the SBC. Plan administrator means the employer who sponsors the plan, typically. That SBC has to be given to participants and beneficiaries who are eligible for coverage under the plan. Beneficiaries really means dependents in this situation. And that will include COBRA qualified beneficiaries, so don't forget that category of participants. For a fully insured plan, there's two types of disclosures going on. First, the insurance carrier is supposed to tell the plan, that really means the plan sponsor or the employer, they're supposed to deliver an SBC to the plan. Then the insurance carrier and the plan administrator of the plan are supposed to deliver an SBC to participants and beneficiaries who are eligible. It's really important to pay attention to this slide and think about the practicality of this. For example, if you have a self-insured plan, don't assume that your third-party claims administrator is going to do this for you. For example, earlier this year, I was helping a client negotiate a claims administrative services agreement with a TPA, and I wrote in there that the TPA was going to be responsible for completing and mailing the SBC, and that claims administrator came back and said, no, we're not. We think that's the employer's responsibility. So we knew that that is something we were going to have to take care of. Likewise, for a fully insured plan, if you note, it says the insurance carrier and the plan administrator have the obligation. As you know, in the real world, when you ask two people to take care of something, invariably it doesn't get done because they each think the other one is doing it. So don't assume your insurance carrier is going to be taking care of this. They might think you're doing it. Well, the good news is if either of you provides it, then that satisfies the obligation. So both parties don't need to provide it, but one of you certainly does. So definitely worthy of a call to the insurance carrier to find out what's happening. Now, when do we have to start providing these things? Well, the general rule you have in your head is anytime you give somebody enrollment materials for the health plan, the SBC needs to go along with those enrollment materials. First time you got to worry about this is an open enrollment period that's starting September 23rd of this year or later. So let's say your open enrollment starts October 1. You need to have these SBCs ready to go and delivered with those open enrollment materials. Outside of open enrollment, your next deadline is the first day of your plan year that starts September 23rd or later. For most of you, that's probably going to be a January 1 calendar year. That means that starting January 1, anytime somebody's eligible to enroll in your health plan, like a new hire or somebody that satisfies their waiting period, when you give them the enrollment materials, you got to give them this SBC. There's a couple of exceptions to that rule. If renewal is automatic, then you only have to give it 30 days before the first day of the new year. So an example of that might be like retiree coverage, where it's part of your active employee plan, so it's not exempt. But with many retiree coverage, the person enrolls in the coverage right when they retire, and then it just keeps going, annually renewing year after year, and the only thing the person can really do is drop out of coverage. Well, in that situation, that's an automatic renewal, and you would have to send the retirees the SBC 30 days in advance of each plan year. For HIPAA special enrollees, they have to be given an SBC 90 days after enrollment. Doesn't exactly make sense because the whole point of this is for people to get information about their coverage, and sort of 90 days after you've enrolled, you're sort of stuck in the option. But there is another rule that anytime somebody requests an SBC, you're supposed to provide it within 7 business days. So presumably a HIPAA special enrollee could ask the plan administrator for copies of the SBCs for all their plan options so they make an informed decision. The next couple of slides are talking about when the insurance companies have to give the information to employers. We really aren't going to talk about these in detail. They're just included for your information. But it is important to understand that as an employer, you've got the right to get from an insurance company one of these SBCs so you can see what kind of coverage you might be purchasing. Next is the distribution methods. So how do we go about getting these into the hands of the participants and dependents? So the good news is that the regulations and guidance have given us a lot of different ways to do this. First, paper is always an acceptable means of delivery. And by paper, print out the SBC, put it in an envelope, first-class mail to the person's address. We know that works. There is a special rule that if you require online enrollment, So, for example, you say to your employees, if you want to enroll in the health plan, you've got to go to this website, and fill out your information and add or delete your dependents. And in that online enrollment site, you can include the SBCs there, so that works as delivery. Then for people who are not yet enrolled, you can post your SBCs to an internet and then give those people like a postcard or an email that says, hey, if you want the SBCs, go to this internet address, you can get them there, or we'll always, of course, provide them free of charge if you so request. And then for people who are already enrolled in the plan, the DOL has said you can use the electronic disclosure rules, which generally is the rule that if somebody goes to work and accesses email from their workplace on a regular basis, means you can email the SBCs to them. So lots of different ways to get the SBCs out there. You always have to provide these free of charge. You can never charge a person for getting them. And the SBC itself can either be provided as a separate document, or you can include it in other materials like your summary plan description, but the SBC has to be prominent. And when you look at the guidance, what it says basically is if you're going to put it in the SBC pretty much after the table of contents, we want that SBC to be the first thing people see in the summary plan description. That's what they mean by prominent. There's something called the anti-duplication rule, which is really helpful because remember, the rule is that the SBC is supposed to be provided to employees and their dependents who are eligible. So that doesn't really mean, though, you have to send a separate SBC to each employee and each one of their dependents who are eligible. The anti-duplication rule says if the employee and all their dependents reside at the same address, or if that's to the best of your knowledge, they all reside at the same address, you only have to deliver to the employee. I read that to include electronic delivery. If you go to your records and you only have one address on file for the family, you can electronically deliver or through your online enrollment, deliver it that way, the SBC to the employee, and you're deemed to have delivered it to all the family members. If, however, in your records you have a separate address for one of those dependents, you really need to find a way to separately get an SBC to that person, probably by mailing to that address. Now, you have to provide an SBC for each benefit package for which the person is eligible. So if your health plan has, a PPO, a high-deductible health plan, and an indemnity plan, you've got three choices. You're supposed to give an SBC for each of those three choices. The only exception is if somebody's already enrolled in the plan, you only have to give them the SBC for the package that they're enrolled in. Again, they can always request copies of the other ones, but you only have to deliver that one SBC. Now, the format of the SBC. There is blank forms available through the government websites, and I will give you that information at the very end. And it's very important that you use that form. For example, you can't have more than 4 double-sided pages. You can't use anything other than 12-point font. To emphasize this point, Casey is going to come back on the line, and we're going to do a little dramatic presentation for you. Casey is going to play the role of that person in your organization who loves to rewrite the employee communications and make them all jazzy and interesting. And I'm going to play the role of you, the listener, who've been paying close attention to this presentation and understand the rule. So, Casey, let's begin.
Hey, Lee. I was looking at this SBC you prepared, and I think we should probably make some changes. I was thinking if we changed to 10-point font, we could include some more information.
No.
Okay, well, how about if we reorganize some of the rows, because I think that will...
No.
Okay. What if we moved the top left header to
No.
Then how about if we...
No. Okay, thank you. That was just our, you can tell we're lawyers and not actors. That's just our fun way, though, of emphasizing, again, with many of the ERISA disclosures, you can change them. You can reorganize them. You can use, God forbid, 11-point fonts instead of 12. You can bold things and shade things. Let me tell you, you can't do that here. There are 15 pages of instructions that go with this little SBC, and the instructions are really clear, like do not bold anything if it's not in bold already. Do not rearrange the rows. Do not change things around. So this is not a situation where you want to get creative. So what is in this SBC? Well, the SBC has 12 content requirements. We're not going to really go through them because, like I said, you're going to pull up the blank form from the government website, fill it in according to the instructions, and be done with it. Can't really do more than that. One of the things, though, that is troubling or is going to be a little difficult about this is there are a couple of coverage examples. So when you go to the form, you'll see that there is a typical pregnancy and a typical person with type 2 diabetes. You're supposed to actually go in and fill out the costs that that person could expect to incur under your plan design. It sounds easy. I think people are finding it challenging, however, to fill those examples out. We also talked about there's this other thing called the Uniform Glossary of Coverage. What this is it's kind of like a mini dictionary of healthcare terms that people are used to seeing in connection with their health plan. And the government felt that people really didn't understand what's a coinsurance versus a copay. What is a deductible? What does that really mean? So the government has defined all of those things. Again, you cannot touch, change, reformat, or reorganize this uniform glossary. It's got to be presented as the government has drafted it. The good news is you don't actually have to deliver this. You only have to make it available if somebody requests it, and you've got to respond to them within 7 business days. It's going to be as easy as going to the government website, printing it out, and handing it to the person. You've done your duty if you do that. Now, what kind of challenges are people going to have with these things? Well, a lot of plans have separate claims administrators for like their medical versus their prescription drug. You've got to have both the information from both of those entities incorporated into a single SBC. So including that covered as examples, you've got to get the numbers in there. So that's going to be a little challenging. Also, you're allowed and you're encouraged, in fact, to explain add-ons. An add-on is something like, if you enroll in the high deductible health plan, we'll throw $300 into your health savings account that you can use to satisfy your deductible. The health savings account is considered an add-on, and you are allowed to talk about that in the context of the SBC for that high deductible health plan option. Also, make very certain that your SBC and your SPD doesn't have any contradictory language. And again, when you're doing those coverage examples, think about them very carefully. There is an online calculator available on the government website where you can actually fill in some parameters of your plan design, and they will spit out those coverage example dollar numbers for you. You might want to use that, although they will warn you it may not actually accurately reflect your plan and what it pays. So it may not be particularly helpful. There is a foreign language requirement similar to other notices. And I will remind you, this is very important, about any changes. So as you all probably know right now, if you have a group health plan and you amend it, you normally have to give a summary of material modifications within 210 days after the change is effective. Or if it's a material adverse change to your health plan, within 60 days after the change is effective. Once these new SBC rules kick in, that all changes. What you now have to do, if there is a material change to any of the information in the SBC, you're supposed to provide 60 days advanced notice. Not after the fact, advance. So if you're changing mid-year copays or you're changing what's covered or what's excluded, And that is something that was otherwise described in your SBC. You've got to get a notice out to people 60 days ahead of time. There's a lot of guidance about these SBCs. There's samples filled out. There's model language. There's blank forms. We talked about all of that. I've given you the websites where you can find that information. And the penalties for noncompliance are pretty hefty, but the good news is the government has said during this first year, they really are going to focus more on making sure people comply instead of coming in and imposing penalties. So that's the good news. And with that, I'll turn it back to Isaac.
Okay, thanks, Lee. So that concludes our broadcast for today. Before I forget about it, for those of you seeking the New York CLE credit, I just want to give you that 5-digit code, which is 1XMPO. Again, it's 1XMPO. And unfortunately, it looks like we're out of time, so we won't be able to answer questions online during this broadcast, but I do know that there were several questions that were asked, and we'll be responding by email to those of you who have asked a question. And just as one more reminder again, we still have our final broadcast this year that will be happening on October 23rd. We hope that you'll join us for that. As I mentioned at the beginning of the broadcast, a copy of these slides as well as the audio will be available within just a few days. And of course, let me go back, sorry. We do welcome any feedback that we get, so we'd appreciate it if you just take a couple of minutes to fill out that survey. And thanks again for joining us. We look forward to hearing from you, and hope you have hope you have a good afternoon. Thank you.
Ladies and gentlemen, this does conclude today's conference. You may all disconnect.